Buenas and half a day. The Committee on Environment, Revenue and Taxation, Labor Procurement, Statistics, Research and Planning is calling this information hearing as well as public hearing to order. It is now 2:04 p.m. Friday, November 3rd, 2023. In compliance with open government law, notices of today's hearing were published in the Guam Daily Post, provided via email to senators, stakeholders, local media, and posted on the Government of Guam Public Notices website on Thursday, October 26th for the 5-day notice and Wednesday, November 1st for the 48-hour notice. Again, the purpose of the informational hearing is to obtain updates on the status of Guam Solid Waste Authority's partial receivership and to provide information on the partial settlement agreement. The purpose of the ensuing public hearing is to receive testimony on Bill 182-37, sponsored by myself. It's an act to add a new Article 10 to Chapter 51A of Title 10 Guam Code Annotated relative to establishing the ORDOT Dump Reserve Fund. The rules of conduct are as follows. Those called to testify will be in the order beginning with those that confirmed. Right now we're going to have a panel, so I'll invite the panel up. And as senators file in, should they come in, they'll be provided the opportunity to ask questions of the panel members. So I would like to invite General Manager Irvin Slike, Andrew Gell, Chair of the Board of Directors for Guam Solid Waste Authority. We have Administrator of Guam EPA, Michelle Lastimosa. And if anybody else wants to join, you're welcome to come. Okay. On Zoom, we have the receivers, representatives, Harvey Gershman, so we'll put that on Zoom. We have Attorney Andrew Mishkin, also on Zoom, and the local representative, Attorney Joyce Tang. Thank you for joining us. So we will start with the informational hearing. I want to give a brief remarks. So the ORDOT landfill constituted Guam's sole landfill for the island's populations, including the U.S. Naval Base Guam and Andersen Air Force Base. The U.S. Navy constructed the ORDOT landfill in the 1940s and deposited hazardous waste at this landfill until the 1970s. After ownership was transferred from the U.S. Navy to the government of Guam in 1950, the ORDOT landfill was Guam's sole landfill for the island's populations and continued to accept municipal and military waste. The creation of military landfill options in the 70s reduced ORDOT landfill's capacity to that of a municipal landfill. Throughout the Korean Vietnam Wars, the U.S. Navy used the ORDOT dump for disposal of munitions and chemicals. According to GovGuam, these chemicals include DDT, Agent Orange. The ORDOT dump's discharge of leachate, much of which entered into the Lonfit River, comprised a significant environmental and health hazard. And the landfill was designated as a Superfund site in 1983. Beginning in 1986, the U.S. EPA ordered Guam to contain and dispose of waste at the ORDOT landfill, or dump, I should say, subsequently suing Guam in 2002 under the Clean Water Act, arguing that Guam was discharging pollutants into the waters of the United States without obtaining a permit. In February 2004, GovGuam U.S. EPA signed a consent decree that ordered GovGuam to close the ORDOT dump, cease all discharges into the Lonfit River, open a municipal solid waste landfill facility, which is now at Luzon, and reduce the amount of materials disposed in the landfill through the use of recycling and hazardous waste strategies. GovGuam was not able to fully comply with the decree in which the ORDOT dump continued operation, and thus the U.S. District Court of Guam appointed a federal receiver. The U.S. District Court of Guam appointed solid waste management consultants of Gershman, Brickner, and Bratton Incorporated as a federal receiver of the former Solid Waste Management Division of the Department of Public Works. In March 2008, the receiver took over operation of the Solid Waste Management Division of the Department of Public Works. In 2011, the Guam Solid Waste Authority was created through Public Law 31-20. The ORDOT landfill was closed, and the Luzon landfill was subsequently opened. The construction of closure facilities regarding ORDOT landfill were completed in March 2016. The contamination resulting from the U.S. military's usage of ORDOT landfill prior to the 70s has comprised a huge expenditure for GovGuam, who has been the sole financier of the landfill's closure and cleanup to date. the continued contamination of ORDOT landfill, its interrelated status as a Superfund site, and associated costs culminated in the 2004 consent decree, the ORDOT landfill's 2011 closure and ongoing post-closure cleanup. 40% of Guam solid waste expenditures are attributed to assigned contracts in ORDOT landfill's post-closure care for fiscal year 21. While the ORDOT landfill's closure and cleanup fell on Gov Guam, the U.S. EPA designated the U.S. Navy as a potentially responsible party in 1986 for ORDOT landfill status as a Superfund or National Priorities List site. In 2017, Gov Guam sued the U.S. Navy for its liability in the landfill's cleanup, corrective action, and closure per the CERCLA, or Comprehensive Environmental Responsive Compensation and Liability Act, Section 107A, or Section 113F3B. While the U.S. Court of Appeals ruled against Guam's suit, the U.S. Supreme Court ruled with Guam on May 24 under CERCLA Section 113F3B. As of September 26, 2023, the U.S. agreed to pay $48.9 million to Guam for the partial cost and care associated with the ORDOT landfill. So we did invite, in addition to Guam Solid Waste Authority and the board, and also EPA verbally today, we also invited the Attorney General of Guam, and we will continue to seek input from them, as well as the lawyer's attorney from ADLU, the governor's office, that is. So I would like to now invite GM, General Manager Irvin Slike, to present his PowerPoint today. And so we can cue that up.
Half a day, Senator and members of the audience. My name is Irvin Slike. I'm the General Manager for the Guam Solid Waste Authority, and I have been...
one moment, please. Sorry, if you can put the mic closer to you. Oh, and sorry, we don't have the visual just yet. My apologies. Okay. Just 1 minute while we cue it up. Thank you for your patience. And I'd like to recognize Senator Barnett. Thank you, Senator, for joining me today. Okay, it looks like we're queued up and ready to go. Thank you, okay. GM. You may proceed.
Again, half a day, Senator Perez and Senator Barnett. My name is Irvin Slike. I'm the General Manager for the Guam Solid Waste Authority, and I've held this position since October 16th, 2021. I've been constructing, operating, permitting, planning solid waste collection, disposal systems for the past 38 years. I've worked in Virginia, Maryland, Connecticut, Florida, and Winnipeg, Canada. I'm here today to comment on Bill number 182-37, which is the creation of the ORDOT Reserve Fund Act. We've created a PowerPoint presentation which explains the RCRA-compliant post-closure financial process. And I know this is after lunch and it's in the afternoon, so I will not go through all the details. The bottom line for GSWA is that we have the potential, if this fund were fully funded, to basically realize a $3 million per year savings. And what that represents for us is about $13 per month savings on our existing 21,000 GSWA customers. This would eliminate the $2 million per year GSW payments into what's created right now as an ORDOT fund, as well as eliminate the yearly inflation payments. So we made 2 inflation payments in 2023. The first one was $1.6 million, and the second one was $1.88 million. And the next payment is due in calendar year 2024, and that's estimated to be about $1.4 million. You can go to the next slide. The RCRA Trust Fund amount is driven by the RCRA prescribed post-closure cost estimate. And if you look at the slide, it's the very top number under 2023, the $27,740,327. That was established in 2021 November, and it was used to create and get the approval on the closure permit for ORDOT, which was signed off and issued by GSWA on April 14th, 2022. That cost estimate kicked off basically the record financial process. If if that $27 million is not in a fund, in a trust fund, you are required to provide the inflation adjustment each year. So that's where those two previous inflation factors come into effect, as well as the third one, which is due in 2024. The parties have agreed to a payment plan for ORDOT, which expires August of 2026. In that payment plan, we contribute $2 million a year, and the costs for ORDOT are then taken out of it. And we'll go through some slides to show you the advantage of fully funding it right now versus waiting the 3 or so years until August of 2026.
Okay, sorry, General Manager. Can you just go back for the listening audience, just talk about what the trust fund does? And so what you're saying here is that if we don't have enough money in that trust fund, then we have to pay more per year, is that correct?
We have to pay the inflation factor until such time as it's made whole, and the time that the court has given us is August of 2026.
Okay, so just can you give more details of what is this trust fund? Why was it created?
The trust fund its purpose is for a regulator, should something catastrophic happen to a closed landfill, have sufficient funds to enact a third party to go in and correct whatever may go wrong in that 30-year period. So the $27 million was produced by Brown and Caldwell, and they listed their normal operations and then what would be required to maintain that landfill for the next 30 years. And then it's annualized, and that's how the figures arrived at. But it's meant to be, a security fund for, in case somebody goes bankrupt, something catastrophic happens, you have the funds available to correct the problem.
Okay, and do you have information about how they got this number? Because, obviously there was a lot of things that were dumped that we don't know. Like, was there really an accounting of what was put there to really have a true understanding of what the cost of cleanup? Because ideally, that's the purpose of this trust fund. Is that correct? Is to ensure that whatever's there is going to be cleaned up and there's going to be no more discharges?
Let me, if you don't mind, my name is Andrew Gale. I'm the chairman of the Guam Solid Waste Authority. Good afternoon, Senator Perez, Senator Barnett. I've been the chairman since, I've been on the board since 2012, the chairman, I don't know, maybe since 2014 or 2015. The purpose of this fund is really to make sure that the post-closure costs of ORDOT are handled. The purpose of this particular fund doesn't have to do with the previous remediation or the previous handling of building of the cap. So what has to go into this, and that's why they call it a post-closure fund, what has to go into this post-closure fund is for all the future expenses to make sure that this cap and that ORDOT is maintained for the next, to call it 25 to 30 years. The regulations call for a specific amount of time. This money is meant to make sure that it is being maintained, that the gasification stuff is working, the leachate collection systems are working, that the leachates is being collected and properly channeled to the Guam Waterworks Authority, that any staffing that is required to do monitoring, sample of the leachate, sample of the gas, that all of those expenses, those future expenses, are covered by this fund. And so it's the way the regulator ensures that the operator, and again, this is a US EPA-based regulation, so it applies throughout the entire US, and you have certain operators that might be private operators, as opposed to government operators, and to make sure that there's enough fund that if something happens to that operator, that the municipality isn't left holding the bag, and the U.S. government and the local government has to worry about that. So that's the purpose of the fund, and there is a requirement. Back in 2016, the district court approved a funding plan for this, which required the Guam Solid Waste Authority to contribute from its revenues, from its top-line revenues, about $2 million a year into an account. And that's supposed to have been building up this particular fund. So that's the it's what is known as the pay-as-you-go plan. So that's the purpose of this fund. Not so much to cover what's happened up to this particular point. Okay, does that clarify?
Great. That's great for the public that would like to get a better understanding. So yeah, that was my understanding when I became senator, that they were gonna take $2 million off the top of the revenues of Guam Solid Waste to ensure that this trust fund is getting the money mandated, right, by US EPA, to ensure the post-closure is done properly.
Right. That was the plan that was created.
Okay.
That was adopted and enforced by the court.
Okay, great. Okay, and so we can go back to the slide. My apologies. I just think that this is good. These questions help better understanding. Okay. Sorry, if you can press your button and then hold it closer. Hold it closer if you don't mind.
Normally, these trust funds are set up so that they are in an interest-bearing account. They have to be liquid because, again, we don't know when stuff will happen. And they're hopefully earning enough interest income to offset the inflation factor that you have to provide each and every year. So you can go on to the next slide.
Just belabor that point a little bit. So you have here in this slide that if you were to have the original amount or the full amount, then is it true that the interest rates will keep up with the inflation costs? Is that
Right.
what the idea is?
That's what the idea is. The bottom line
okay.
is if we were able to get approximately 25 million, it would take the money that's already in there, 7.1 million, and that would be more than what the inflation factor at 4% estimated would be. That bounces around, but that's the general idea, is you try to keep your investment interest ahead, or even if you fall behind, you're not asking to come up with, $1 million or so. It may be only a few $100,000 that you have to contribute to true it up.
Thank you for that.
So what this slide conveys is currently the fund has 7.1 million. The agreed upon amount that we know right now with the 2 inflation factors, et cetera, is about 31, maybe 32 million. We'll know more in 2024. And these list the upcoming payments, the 2 that we made this year, and then the third one, which is due in 2024. You can go to the next slide.
Sorry, General Manager, so this meets the requirements of the consent decree, is that correct? What's currently in the trust fund?
This keeps us compliant with RCRA. So once the closure plan was adopted in January of 2022, we were required to make these interest payments and make this fund whole, even though we had a payment plan up to 2026. Yeah.
Thank you.
So let's see where we're at now. You can. So what's happening right now is we are contributing $2 million per year. The ORDOT Brown and Caldwell contractor roughly is about 1.1 million. We've put together an estimate of what we think the remaining problems that ORDOT will take to potentially remediate. We think it's around $1 million. What's happening with the current payment plan is we're putting $2 million in paying out the contractor at 1.1, so we're only netting $900,000 per year to true up the existing fund, which is why I think it was created in 2018, why it's currently only at $7 million. Go on to the next slide. Okay, this shows the status quo, which is if we continue going down this road, wait till August of 2026, we'll need at least 26 million to true the fund up, because the bottom line shows where we're at now with 7.1 million, and then making the 2 million contribution, but still paying the operator out of that, and only netting 900,000 puts you at that amount. So at the end, we'll be at 9 million. But the inflation, again, the 27 million earns an inflation factor each year. That grows to...
Okay, sorry, before you move on, can you just, okay, so basically, I may have missed this point earlier. You're saying that there was a requirement to have a certain amount of money by 2026. And what amount is that?
Let me,
sure,
if you don't mind. I am usually a little bit better explaining it in layman's terms because Irv gets too technical. He's wrapped up into regulations. So, and I'm not in the profession, so I'm going to try to help explain it. So backing up, right now, as you know, Guam Solid Waste Authority is operating its deposits and collections. Collections of residential trash, collecting. It takes commercial trash and operates the landfill. So the last piece of the receivership is the ORDOT post-closure dump, and so that's what is remaining in the court today. There is a permit that was filed with the Guam EPA and the US EPA that was filed by the receiver as because they are still in charge of the ORDOT dump, the ORDOT management, they're still in charge of the ORDOT dump. That's the last piece that is under receivership. Everything else with Guam Solid Waste Authority is under the control of the Guam Solid Waste Authority Board and Management. So that, in order for you to file that permit to make sure you're running that you're operating that closed dump, you have to file a cost estimate, and that cost estimate was filed in 2021, according to regulations, with the permit, and it was around 22 million. Now, was it 27? I'm sorry. It was 27 million at the time, and it said this is what you need in your fund to be compliant with all of these regulations. Now, part of the regulations say that fund, this post-closure fund, has to be updated annually for interest. And so that's where we were talking about the interest rates. But today, there isn't that amount of money in the fund. There is only $7 million in that fund. And so that fund, and that fund wasn't earning enough interest. It wasn't in the right account, so it didn't earn very much interest. It has since been moved into an interest-bearing account, but the amount of interest that would be created on that $7 million is not going to be enough to cover the inflation adjustment for the larger amount, which is the $27 million, the regulated amount. So essentially what Irv is proposing here is by the time the next adjustment for that fund balance comes in, which is 2026, that fund needs to be made whole. It needs to be made whole in the eyes of the regulator, which is Guam EPA and US EPA, and it needs to be made whole in the eyes of the court. At least the court has to have the feeling that there is going to be enough money in this post-closure fund. The court has made it very clear that that is paramount in their decisions on deciding whether or not the receivership ends. So to getting to that particular end, we've got the idea of We've only got $7 million in this fund today. By 2026, the fund has to have on the order of $36 million. So at that particular point in time, Guam Solid Waste Authority will have to come up with approximately $26 million to make that fund whole. And that's why we're here today in support of Bill 182, which would take the proceeds of the settlement with the U.S. government, Department of Navy, and take those proceeds that are supposed to pay for the payment of ORDOT and put it into this fund so that we can relieve the Guam Solid Waste Authority revenues from paying into that fund any further.
Thank you for that explanation. That definitely clears it up. Okay, so and of course, that amount, so that's the estimate amount?
That is correct.
Okay.
These amounts are estimated. They'll change based on actual inflation factors and actual interest rates. Yeah. I said these are estimates, like you said, but they'll based on actual inflation factors and investment interest that's actually earned. But they're roughly what you'll be looking at. And again, like Andrew said, we do advocate the earlier truing up of the fund because, again, this was, as I mentioned earlier, save us about $3 million a year, benefiting our current GSWA customers, and it would facilitate the end of that 19-year consent order. Go to the next slide. This slide lists under the last court status report the 4 elements that are necessary to facilitate the end of the receivership. And federal EPA is coming in next week. They're going to be working with GEPA to look at the special environmental project, which is the household hazardous waste facility, to make sure that the final report is complete. That's a certification of the construction of the household hazardous waste. The certification that the ORDOT dump no longer receives municipal waste. That's to be done by the receiver. And the execution of the custodial trust agreement is what we're speaking on today.
Are these already, can you go into more detail about these items? Are they pretty much they're close to being certified?
Right. The last court hearing, the judge gave us 2 months to come up with these. So the last one, the execution of the, that's already been worked on as a part of the closure permit back in January of 2022. So that document is in existence and agreed upon by all the parties. The other 3 above it are, well, the one is an easy one to do. It's just a letter saying that the ORDOT no longer takes waste. And the other 2 are within GEPA's control. And again, like federal EPA is coming in next week, and they should be able to finalize those 2 reports.
So, General Manager, so can you go into like, what is the supplemental environmental project? What is that? Is that, you said, is that related to ORDOT?
That's the household hazardous waste.
Oh, household.
At Harmon.
Yeah. So one thing I'd like to clarify here, the list that Mr. Slag just showed was what we're proposing to terminate the receivership, but it's not, it wouldn't fulfill the consent decree completely for ORDOT. The last thing that has to happen in order for that to be fulfilled and for Gov Guam and for the Department of Justice and the US EPA to be satisfied is there has to be a certification that there are no more discharges into US waters. Remember, that was the whole basis of the lawsuit, was the US EPA sued Gov Guam because we, like you said in your opening statement, we were discharging pollutants, leachate, into the waters of the Lanfit River. So while this we're proposing this as a way to terminate the receivership, those 4 items above, the fifth item, item to terminate the actual, to complete the consent decree would be a certification of the cessation of discharges into the L'Enfant River. That might take a little bit longer, that because of the mitigation steps that Irv was alluded to earlier. So that might take a little bit longer, but we are proposing that we have the financial and technical wherewithal within the Guam Solid Waste Authority to do that. The US EPA and the Department of Justice in the reports submitted to the judge agreed with that. They did think that we have the technical and financial wherewithal to complete that certification. It was brought up in the last court hearing. The receiver mentioned that there might be some issues with that, and the judge was going to take it under advisement on how we do that. But our position is that we could the receivership could end if those 4 points were satisfied. And one of those important points was that last point, which is the fully funding, or if the judge sees that the Guam Solid Waste Authority has the capability to fully fund that trust fund based on RCRA requirements.
Okay, sorry, can you repeat, what were the 4 points that
So
you're
the 4
proposing?
points was the SEP, right? So the SEP stands for the Special Environmental Project. So there has to be a certification that project is complete, and it is complete. So that certification is forthcoming. The second one, I'm sorry.
Construction of the household hazardous waste, which is done.
The construction of household hazardous waste. We have to certify that ORDOT is no longer accepting municipal waste, and it hasn't accepted municipal waste. So that's just it's a formality. And then the fourth one was the ensuring that the funding of the post-closure care trust fund is there, right, to fund that, or at least identify how it's going to be funded.
Right, thank you for that clarification. Is there anything else that Guam EPA would like to add to this?
I think one of the bullet points was, I'm sorry, Glenn's Nicholas Guam EPA was also the succession certification of leachate from the ORDOT.
So would you say succession? I didn't quite hear you.
Yeah, secession.
Okay.
It's basically to ensure that leachate stopped.
So that was the last thing. In order for us to, there has to be a certification that the leachate that the pollutants are no longer flowing into the waters of the U.S. Right. So that's the fifth one. But that, like I said, what we've presented to the court is that may happen later, and it doesn't. The receivership can end prior to that. That's what we're saying to the court. It's in our the fifth and the sixth reports.
Okay. Yeah, I guess we'll talk a little, do you mind if we talk about the leachate? I know there was an issue with that. There was a break in the water line, and I believe GWA general manager said that they're willing to concede that they may have been that may have been one of the reasons why there was increased leachate. Since have they fixed that line, that water line since?
Yes, that was fixed December of 2022.
Okay, and then what is, are we seeing more leachate?
We saw a dramatic drop in the dry season. It started to pick up again. The last technical meeting we had, which was today, Brown and Caldwell is of the opinion that groundwater intrusion is just to be expected, and that as soon as we go into another dry spell, we'll see a lot less leachate. We've been advocating that they look at other solutions to, even though the majority of it seems to be taken care of, since we're the ones paying for the leachate bill, we would like to make sure it's as low as possible, and we look at all avenues. And that's what that remediation money is meant to do.
So is this one of the 4 points that's listed?
It's
No, it's not. The amount of leachate generated is kind of a separate topic, right? As long as the leachate isn't flowing into the waters of the U.S., it doesn't apply to the consent decree. What it does, though, is if somehow groundwater is getting into the leachate collection system, and it is going through and then it thus going off through Guam Waterworks Authority for treatment, it's increasing our operational costs. It increases the operational costs of operating the ORDOT dump, the cap. And so what we're trying to, first of all, we need to make sure that there is no more cessations, that the seeps are filled and there is no more discharges into the river. So that's one project. And the other project is trying to determine why there seems to be this increase in leachate amounts. Over the from 2018 to 2022, the receiver, reported in 2022 that the amount of leachate collected has increased over time, and that's not normal. If once you cap the landfill, it should go down, and it was almost in a straight line. So something was going on. They had identified in 2022, they had identified a water leak with Guam Waterworks Authority. Guam Waterworks Authority came out and fixed the water leak, and they noticed an immediate drop in the amount of leachate. So it was no longer a straight line going up. It was going down. But then it was noticed during rainy season, whenever it rained, that the leachate would go up, and then the rain would stop, and then the leachate would go down. And then it would rain again, the leachate would go up, and then it would go down. And you don't want that. You don't want your rain to influence the amount of leachate, because that means your rainwater somehow, either surface water or groundwater, is somehow getting into your leachate collection system. You typically would want your stormwater system to intercept all that. So you're not paying to dispose of it as you're not mixing it in with leachate, right? So that's what we're trying to do. And as an operator, we want to, if we can solve that, if we could spend a little bit of money now, it could save us, save our leachate operational costs down the line, and there would be an obvious return on investment.
Okay, thank you. Thank you. Yeah, basically they're two different issues, but
Right.
somehow related to at the same time.
Right.
Yeah.
So the receiver has written a letter to the Guam Waterworks Authority, to Miguel Berdalio, and asked them for some type of compensation for the leak. And they're still going back and forth as to what that amount would be. The receiver has presented one amount. Guam Waterworks Authority is doing their studies, and they're probably going to come back with a different amount. And so that's still ongoing as to what that compensation might be returned to Guam Waterworks Authority, Guam Solid Waste Authority.
Okay. All right. Thank you so much. Okay, so sorry, we can move on to the next slide if you're ready to move on.
No. Next slide, please. So I just want to kind of close with giving you an update on where the GSWA as an organization is. We've been able to hold expenses, complete basically problem areas that we identified in 2022 and complete them. We now have, in 2023, 6 new trucks, so our fleet is upgraded tremendously. We've been able to sort of wean ourselves off of temporary employees. That was one issue that we came in 2019 out of the receivership that the PUC wanted to see addressed, and we were able to reduce staff by 24%. We had issues in 2022 about carts, again, long lead time with the supply chain problems, but we've got those solved as of today. We were able to hire a mechanic, and we've reduced our maintenance costs by 49%. When I got here, I think we were spending about $1 million on maintenance of the trucks. With the contract renewals that have come up, we've been able to save on the Lejeune operation contract about $1.4 million annually. And we've saved about $400,000 by bringing in to our operational group the people that man the household hazardous waste facility. And the last slide. The crew is really happy with the new truck additions. So,
And so I think most people are in the community, they're very happy that regular service. And, you know, also thank you during Mawar. I think that was tough times, right, to have to deal with a large amount of trash and having to catch up with the scheduling as well. Okay, so yeah, I do appreciate all the improvements that Guam Solid Waste has done, and very frugally. I know since Larry Gast, both you and Larry Gast were very cost conscious, finding ways to reduce cost, and also thank you to Kathy Kagigi also as well. But I do have a question for
Sure.
I guess, we'll talk about the settlement agreement too as well. So, but before we move on, I would like to maybe ask the input of the receiver in that if we can put on the screen the receiver's representatives. Yeah, so I guess the question I have is, as far as termination of receivership, you know, in the last court appearance, can you maybe, from your perspective, what was required for the ending of a receivership? And I guess it can go to anyone. So this is Harvey?
This is Harvey Gershman.
Gershman, okay.
I'm the receiver representative. I'm going to ask Andrew Mishkin to answer that question, and would encourage you to turn to the special report we submitted to the Guam Solid Waste Authority on question 12. It outlines it on page 11. But I first want to just say something about GSWA's request for $25 million early to be put in the trust fund. It's an excellent request. It will save money down the road. And I think if that can be accomplished, that would be a wonderful thing for the fund to have, and be able to invest that money, as well as provide GIPA assurance that there's funds for post-closure operations and maintenance and other things that might come up. So I just want to, underscore our support for that request of $25 million. Andrew, could you talk about what's on the report we presented to GSWA?
I'm sorry,
You're on mute. You're on mute, Andrew.
So this is Andrew Mishkin, the attorney.
He's
You're
counsel
recognized.
to the receiver. He's one of the counsels to the receiver.
Yeah. Okay.
And I hope I'm no longer on mute.
No, we can hear you. Thank you. You may proceed.
Good. When the court appointed the receiver, the court actually laid out pretty clearly when the receivership would be able to end. And that is at the bottom of page 10 of the special report. But I will just read it for you because I think it's worth going over, and it's short. This appointment shall be for the period necessary to achieve compliance with the consent decree, unless the receiver recommends termination of this order as no longer necessary or modification thereof, and said termination or modification is accepted by this court, and B, the receiver requests to be relieved, and such request is approved by this court, or this order is otherwise modified or terminated by this court. So that really is the fundamental framework for all that is going on. And what is being proposed, which we are not objecting to, is essentially to come to an understanding and develop a level of confidence that the consent decree will be complied with. The remaining aspects of it will be complied with, without the necessity of the receiver remaining on board. But this is a complex process. I think the previous presentation by the GSWA manager described some of it. There's there's even more details than that, because in addition to the consent decree, this post-closure financing and actual physical post-closure is governed by the Federal Resource Conservation and Recovery Act, lovingly called RCRA by the environmental types. So it is something with many moving parts, but fundamentally, what we are trying to do is get to the point where either we have fulfilled all the requirements, which we are very close to doing, or we are close enough and the receiver is confident enough to ask the court for the court to terminate the receivership. But ultimately, that decision is the court's decision.
Okay.
Andrew, do you want to highlight the 9 items on page 12, or not, or just?
I think Irv covered some of them. Yes, there are 2 technical memos that have been submitted but need to be finalized. We're awaiting some comments and input from the regulators. There's a trust agreement that must be approved by US EPA and GEPA, which Irv referred to earlier, which we call the RCRA trust, and that is in process. That is not something that's going to be a difficult hurdle. The RCRA compliant post-closure care financial assurance must be provided, and that is where the request for the $25 million funding will resolve that. 99% of that issue will be resolved with that money being placed in the trust fund. And then
let me interject on that point. Right now, we're writing the trust agreement to continue with the $2 million per year payments monthly through August 2026, and writing it to include the requirement for inflation payments and the balloon payment, as Irv referred to it, to come in at the end of 2026. That's the way it's written. It's also written that the fund could be funded in advance of the balloon payment if funds, are made available by GSWA to this RCRA trust fund. So we're writing those requirements, with flexibility, and but right now, the only way that EPA has said that they will, approve the trust agreement is if there's agreement on the balloon payment that would be necessary to fully fund the post-closure costs after August 2026. Okay, go ahead, Andrew.
Yes, and just as an aside, we have been given more flexibility. Guam has been given more flexibility in this funding than the RCRA statute and regulations actually require, and that has been very helpful to Guam financially. The next critical item is the requirements in order for the receiver to seek court approval of the termination of the receivership, which is a determination by the receiver that GSWA is able and prepared to take over responsibility for monitoring and supervision of the operator performing the post-closure work at the dump, and to complete the technical work relating to the dump post-closure care plan, both of which are currently being performed under the supervision of the receiver. And then the remaining items are more administrative. The services required from consultants to complete the work must be paid from the through the contractual arrangements and the successor to the trust fund. There is an ongoing investigation of seeps at the site, and there was an increase in leachate generation between 2018 and 2022, which has now been reversed and appears to be significantly going down, but there's still an investigation of what did happen and whether there is any likelihood or possibility that that will happen in the future. And that is a critical issue in order for the certification that we have been talking about to be issued. And that really brings in the last point, point number 9, about the requirements for that certification, which is really the critical and last step in terms of substantive compliance with environmental requirements in order to have this closed landfill be legally and safely closed.
Okay, thank you for that. So I just have a further question. So are you prepared to agree to a termination if Guam Solid Waste can show financial and technical capability to properly carry out post-closure pursuant to the US EPA standards and Department of Justice? And
I'd like to defer to the receiver on that one.
Yeah, the court will be the ultimate decider on that. We would report to the court, our opinions on those matters, and so the court can consider this request to end the receivership early. There's a very significant representation that has to be made in the cessation of pollutants to the L'Enfant River from the ORDOT dump, and it's something that we're prepared to do once we're in that position, and the dump data and performance is recognized as such by the regulators. And we're not sure that that's an opinion that GSWA can make. And we're reviewing that and talking about how to deal with that issue and representation that's required by the consent decree in saying that leachate and pollution in the L'Enfant River has stopped from the ORDOT dump.
And we have an understanding with the regulators, with Department of Justice and Guam EPA and US EPA, that this is a critical issue, and we need to work out the manner in which that can be accomplished. So it is a goal that all the parties have recognized is not easy to attain, but that we are working toward.
Okay, and then, so it's my understanding, so the receiver is responsible for the post-closure. In this document provided, it states that identification of possible remedies for the leachate generation. So is it my understanding, is it correct to say that, so is Brown and Caldwell in charge of carrying out this work?
Brown and Caldwell is the receiver's engineer and operations contractor at the ORDOT dump. They have two functions. We turn to them for their technical work. They've prepared a technical memo that outlines some remediation steps and are about to undertake a feasibility study to develop the costs of those. Irv mentioned $1 million as a order of magnitude number for some fixes. At this point, we concur that's a good number to have in mind. But we'll know more about that in the next few months. You should know that I've said to my team that I have I've set a target to end the receivership on July 1, 2024, if at all possible. And that will require, us all to get together on these issues and find solutions that are acceptable to the court, not as well as to us. The court is the ultimate decider on when the receivership ends and under what terms.
Okay, thank you. The other question I have is, so what, do you have any contractor working on the remedies? So there was, we were talking earlier about, the leachate should be going down, but we're seeing an increase. And what has
The
been
leachate,
done? Yeah. So what has been done?
the leachate since the December fix by GWA in 2022 has been reduced by over 50% in year-to-year comparisons so far, or month-to-month comparisons. A tremendous reduction. Brown and Caldwell has developed some options. They're being evaluated so that we can talk about implementing some of them in 2024. So they are being worked on.
Yeah, but the other thing that was mentioned earlier is that it increases with rainy season, so that indicates potential infiltration from the groundwater. So has there been any remedies in place, or that is being planned for?
I'm not the engineer on the project, but my understanding is that this site sits on bedrock, and the groundwater, there's no bottom to this dump. So it's not the groundwater will come up when significant rains happen, or there's a big GWA water leak, apparently. And we're trying to figure out if there's are some remedies that can slow that groundwater rising into leachate that's dripping down and misses the collection system. But this was known in the original design. The solution to this, the foolproof solution would be to dig up the entire ORDOT dump and move it into fully lined, record design cells at Lauzon or some other location. That is prohibitively expensive. The leachate system is performing excellently. Very, very little of the leachate that's been collected has left the system. We don't know, how significant these seeps will be post the GWA leak being fixed. That's being evaluated now.
All right, thank you. Are you seeing a decrease in discharge of pollutants from the ORDOT dump?
On a daily basis, we do not discharge pollutants. There were 3 incidents. I think 3 is the number, 2 of which were mechanical or power related that caused some leachate to leave, collected leachate to leave the system. One was an overflow during a very heavy storm. And then the most recent, the 4th one, was during the typhoon Marwa, where the system shut down, like most of, electrical systems in Guam shut down during Marwa. And we were down for, I think it was about a day and a half. And the system, did overflow. But overall, when you look at all the gallons that have been collected and processed and pumped to GWA, a very, very small percentage. What was it, Andrew? 0.004% of all that we've treated was documented as leaving the system. But it's not perfect. and we're trying to make it perfect. The consent decree cessation requirement is perfection. It says no, discharges. No means none, means zero. We're not quite there. We're close, but we're not quite there.
Okay, so it seems like when the power goes down, that's when the problem happens, or extreme storm events. So, okay.
We have seen leachate quantities go up after large rain or storm events. Yes.
Sorry. Attorney Michigan, you're mute again. If you wanted to add to that. You're still muted.
Okay, thank you. In fact, one of the projects being worked on as we speak is the hardening of the pumps and the electrical system and the monitoring of the power at the site, so that when outages occur, there, I believe, will be backup systems that will be available to keep that going. So that is in the process of improvement in the event that there are other severe precipitation events, although a really severe typhoon can overwhelm any system, but this will be more resilient even than it is currently.
Yeah, thank you for that. Is it possible to get FEMA funds for that? Can the receiver obtain FEMA funds?
Senator, our engineer receiver is talking with Irv about that, and we can investigate that, make sure we pursue it.
Thank you so much for your input. And so I would like to move on to the next item, which, I'm sorry, not into the public hearing just yet, but about the settlement agreement. So I know a lot of this, maybe if I can get your understanding of what took place. I mean, this was really a landmark decision, I believe. I mean, maybe Chairman Gale, if you can talk about this.
Yeah, sure. So, like I said in your preamble there, in your introduction, the Elizabeth Barrett Anderson, the Attorney General at the time, in 2017, decided that with advice of a firm out of California, I think out of Texas, Kelly Dry, decided that there was a case that we could take the CERCLA case and have some contribution to the costs of paying for the ORDOT dump remediation. And so it went through the court motions, and one of the things that happened, which was interesting, was even before it got to the discovery of the case and all that, the court, the U.S. government said, hey, filed a motion, says you've violated the statute of limitations. There's some timeline that that expired. And so it went through that machinations all the way up to the Supreme Court. It went all the way up to the Supreme Court, and the Supreme Court eventually sided with Guam that no, they can sue you, and you guys should go ahead and continue figuring out, how much you should contribute. And so after that Supreme Court ruling, there were discussions and negotiations that took place, led by the governor and her team, with contributions from the Attorney General's office, with the Attorney General's office, and they came to a number. But what they're doing is they're calling it a partial settlement. So they came up to $48 million for I forget, for a certain amount. And then once we settle on the final costs going forward of the ORDOT post-maintenance, ORDOT post-closure fund, then they can settle on that final amount. But that amount came in at around, again, like I said, $48 million. A portion of that will go to the attorneys for their contingency fee. A small portion will go actually to the U.S. EPA. That was part of the agreement, was we would fund part of the U.S. EPA's for the work that they did to bring this cause to light. And then the rest would flow to the government of Guam. And again, as you know, the legislature has the power of the purse. So we're hoping that we can appropriate that money for the purposes that we've discussed and for the purpose of Bill 182.
Just explain, why is it a partial settlement agreement?
Right, because at the time that these was going on, the post-closure fund amount and that final amount hadn't been decided. Yes, a permit was filed in 2021 with a post-closure amount, but as the receiver explained, those numbers seem to be were in flux due to certain things, the amount of leachate, the cost of the leachate disposal, those other things. So fixing all of those items are giving us a clearer picture of what those future costs would be. And so because those costs weren't settled, particularly they weren't settled in the eyes of the court, of the U.S. District Court, that's why they had agreed to settle it at that particular point and then come back later to do the rest. That's what I understand. Again, I wasn't part of any of the direct negotiations. I've just been informed about them.
Are there any restrictions as how this money is going to be used? So, for instance, specifically, so if we're awarded this amount, it has to go specifically to post-closure. Is that the settlement? What does the settlement say?
I'm not qualified. I don't know if anybody here is qualified to answer that question. I haven't. I'm not sure. I wouldn't want to go out on the record as answering that question. I would defer that to the governor's legal counsel, Jeffrey Moots, or the Attorney General.
Thank you. And then do you know how much lawyer contingency fees are in the US EPA?
I believe it was 25%, again, something like 25%.
25% of the settlement?
Of the settlement amount.
Okay. And I believe at one time there was 160 million, right? Is that correct? There was a much larger amount that was...
Well, right. I think that was when, I think originally when Kathy and Director Byrne from the Department of Administration put together the full costs, they presented a number, said here's the total cost. And so then there was some jockeying, and then they figured out, okay, here's our portion of that.
I think the settlement was a percentage of that, and they want to apply the same percentage to the future costs as well.
Right.
That's my understanding.
Right.
So it's a portion. So what portion was government of Guam?
I don't know.
I don't know. I know that we were involved late 2021 or into 2022, providing Kelly Dry and the governor's office with the full cost of what it costs to permit and build Jean, as well as close ORDOT and all the other ancillary costs. So that's something we put together for the lawyers, and I believe that was the 160 million, if my memory serves me correct. But as for what I know, it's the negotiation was a percentage of that.
So
The Navy wasn't liable for the full amount. It was a portion of that.
do you want to add to that, Andrew?
No, that's right.
So does that mean the other party is going to pay additionally, or this is it? This is all?
That's the way I interpret the wording of that agreement, and they talk about it being, I forget the exact terminology, partial or something. Partial, yeah, so that as soon as the future costs have been determined, then the parties can reconvene and determine what that additional contribution might be.
And when is this supposed to, when are the settlement agreement, when is that going to cease? Or is there a time frame? Or is it
I think there was a funding for 60 days. Again, I would defer to the Office of the Attorney General or
okay.
Jeffrey Moots from the Governor's Office.
Yeah, okay. We'll definitely reach out to both. I mean, we did invite Attorney General's office, and we'll definitely reach out to both parties. Okay, is there anything else that you would like to add to this, Administrator?
Good afternoon. Considering that I just got the invitation an hour ago, I have not had the chance to look at the bill, but I certainly will take the time to read it and provide testimony at a later time, if that's okay.
Thank you. I appreciate it. Or just, yeah, if you knew anything about the settlement agreement too as well. All right. Appreciate you being here. Okay, so we're going to, is there anything else that you would like to add about the settlement agreement or the partial settlement agreement at this time? Okay. So this concludes the or I'm sorry, I want to reach out to the receiver. Is there anything else that you know about the settlement agreement that you would like to add to this?
No.
Okay. All right. Well, thank you so much for your participation in the informational hearing. We are now going to move on to the next item of the agenda, which is the public hearing to receive testimony on Bill 182-37. And I'll just give some opening remarks. First of all, let me just give some closing remarks on the informational hearing. So Guam Solid Waste has made important strides in gaining greater autonomy by attaining partial receivership since 2019. One of the remaining but very critical pieces of ending receivership's role is to have an adequate financial capability, and as also we've heard today, technical capability, to achieve post-closure requirements towards cleaning up our environment and water under the U.S. EPA consent decree stemming from violations of the Clean Water Act. The Supreme Court's recent ruling for Guam to not solely foot this bill is a landmark decision and one that can greatly assist with this objective. We must ensure that post-closure is done properly and financing is adequate to clean up our hazardous waste, especially with the hazardous nature of many chemicals and munitions used for warfare and emerging identification of hazardous chemicals that were used by the military, which is the largest generator of hazardous waste on Guam, industrially and commercially. Okay, so this concludes our informational hearing. We will move on to the next item, which is the public hearing for Bill number 182-37, sponsored by myself. It's an act to add a new Article 10 to Chapter 51A, Title 10, Guam Code annotated relative to establishing the ORDOT Dump Reserve Fund. So the Bill 82-37 aims to create the ORDOT Dump Reserve Fund, which shall be maintained separate and apart from any other funds of the government of Guam, including the general fund. And this fund shall be a continuing fund, and amounts credited to this fund shall not be subject to further appropriation, and monies remaining in this fund at the end of a fiscal year shall not be transferred to the general fund, and this fund shall not be subject to transfer authority by the governor. The fund shall include all money, payments, and other things of value in the nature of civil damages or other payments received by the Treasurer of Guam relating to the partial consent decree approved by the U.S. District Court of the District of Columbia on September 25th, 2023, in the Government of Guam versus United States of America, case number 117CV2487, in which the U.S. agrees to pay the Government of Guam $48.9 million. Additionally, the fund shall include interest earned on such amounts. The Treasurer of Guam shall promptly credit all money, payments, or other things of value received pursuant to the partial consent decree identified in this bill. Guam Solid Waste shall administer this fund. Lastly, the bill states that Guam Solid Waste shall report annually, no later than October 31st of each year, on the activity, revenue, expenditures to and from the ORDOT Dump Reserve to the governor and to the legislature, to the Speaker of the legislature. The report shall include the following: revenue credited to the fund, expenditures attributed to administrative cost and support, and an itemized list of expenditures in addition to other things. And so at this time, I would like to receive testimony on this bill. So you're recognized, General Manager, for your testimony.
As I said in the informational meeting, my name is Irvin Sleck. I'm the General Manager for the Guam Solid Waste Authority. Held this position since October 16th, 2021. I've been constructing, operating, permitting, and planning solid waste collection, disposal, facility systems for the past 38 years. And again, I've worked in Virginia, Maryland, Connecticut, Florida, and Winnipeg, Canada. I'm here today to comment and support Bill number 182-37, the creation of the ORDOT Reserve Fund Act. This act, if enacted, we're looking at, using $25 million to relieve ourselves of $3 million per year expenditure and this would benefit the current 21,000 GSWA customers, potentially reducing their monthly fee by $13.
And that concludes your testimony. I know you provided written testimony, and I realize that you did your presentation, was supposed to be part of it. Does that conclude your testimony?
Yes, pretty much. I think given what in the informational session, the interest payments that we would have to come up with under the current payment plan are more expensive than if we fully fund the trust fund immediately. So again, using the proceeds from the settlement and putting it into the fund that's described in Bill 182-37 would be the greatest way to save monies for our additional customers, as well as take a huge step towards convincing the court and the U.S. government that Guam is serious about taking charge of and managing its own solid waste disposal system.
Okay, thank you. So regards to, so I know there's a trust fund that already exists, right? So I guess why would you support this?
The settlement money of $25 million combined with the existing $7.1 million that's in a receiver fund together would put us in a position to be fully compliant with EPA regs in terms of ORDOT's post-closure fund requirements.
Okay. Okay, I don't have any other further questions at this time. You have anything to add, Chairman Gale?
Sure. So my name is Andrew Gale. I am the chairman of the Guam Solid Waste Authority, and I am pleased to testify at this public hearing for bill number 182-37. GSWA has been placed in various precarious situations over the last several years based on its revenue that it's produced and the fixed cost requirements that it has. Today, we have, among our costs that we have to pay includes a debt service for the construction of Cell 3 at Ladzon of $3 million a year, plus we pay $2 million a year into this ORDOT post-closure fund. So $5 million comes right off of our revenue to pay these debts. As a responsible municipal solid waste operator, we should also be putting money into a reserve fund for future expenses. These future expenses would be things like vehicles and trucks. It would be things like developing new landfill cells. You know, Ladzon anticipated 10 cells, 9 or 10 cells. So we'd have to pay for the future construction of those, plus we'd have to cover cells 1, 2, and then eventually cell 3. So while we are generating revenue, while we're in the process of generating revenue, we should be setting money aside to pay for those future expenses. But because of this situation that we're in, we haven't been properly funding those reserves. And it's something that we're having to deal with from a management perspective and from the board perspective. So the way we would do that is we need to somehow either increase our rates or borrow more money. We don't want to borrow more money in the future. So we actually have analyzed increasing our rates. If we were to allocate this fund money here that has been specifically given to Guam in light of the expenses that we've had to incur to fix the ORDOT dump, to remediate it and bring it into compliance, this would alleviate so much pressure on the revenue, the rates that we would have to charge our ratepayers in order for us to continue to fulfill our regulatory obligations. And those regulatory obligations have to do with a municipal solid waste system that meets all of the local and federal requirements. So again, I wholeheartedly support this bill. It relieves pressure in a future payment, which we may have to pay. We may in two years we may have to figure out how to come up with $26 million to meet these regulatory requirements. We wouldn't have to do that. It also would relieve us from paying about $2 or $3 million a year of our revenue into a post-closure fund, thus could relieve that rate pressure, that pressure to increase rates, which would mean we can we wouldn't have to increase rates, and then we could start properly making sure we're properly funding our future obligations and requirements that would keep us in compliance with the regulators, as well as fulfill our duties as stewards of the environment. A little too much? Okay.
If I may add to
Thank
Andrew's
you, Chair Miguel.
eloquent
Discussion. GM
So
Slide.
we actually ran the numbers. So if we could not get the requested $25 million to true up the fund with the existing receiver $7.1 million, and we were required to come up with that balloon payment that I showed in the informational session of about $26 million, we would need to immediately start with our existing 21,000 customers a $40 per month increase on top of the $30 that they already pay to build the fund up so that we could make that balloon payment. The other option would be for GSWA to borrow money, and Kathy could give you better information, but we're a new organization, and we don't have a sort of credit history. So for us to go and ask for $26 million would be a big burden. We may be able to get it. Kathy was, not really encouraged by that. The second thing that a lender would look at us with, and this leads into one of the bills that you're looking at in the future, is a lender would look at us and go, so you're only collecting from half of the available population and you want $26 million? It's not a good look. They wanted to make sure that whatever money they lend, you're able to fully recover from whatever population that you have. So that's what we looked at the numbers. It's going to be a huge increase should we not be able to get this. I couched it in my discussion about the savings, but there's also a cost to try to come up with that money in 3 short years too.
I mean, I totally agree. I mean, if we can pay for it rather than financing it. Financing doubles the cost pretty much. And that's the way we don't want to go. And I understand that, with the money coming in from the settlement, if that can go towards post-closure, that would definitely help mitigate that increase. Would you say $40 increase? But then it also would, like you said, the $2 million that's taken off the top every year, that could go towards the reserves, right? The reserves for
future, exactly.
Yeah.
Go towards future reserves and relieve the pressure to increase rates.
Yeah. Okay. Okay. I appreciate it. I appreciate any other comments or testimony. Does the receiver would like to provide any testimony at this time? Okay.
Yes, I can make a comment. I think it would be very, very good to have a portion of that settlement be earmarked and go to the RECRA trust agreement. I will point out that the funds need to end up in the RECRA trust agreement and not stay in a separate trust fund. This agreement that will be put in place is the one that, follows RECRA requirements and is anticipated by the regulators to be put in place. So I think it's a very good idea, and I'm got my fingers crossed that the legislature will go through with it. And Senator, thank you for allowing us to be present and make comments today with you. Appreciate it very much.
Hagamas, thank you so much for joining us. I know it's probably really late where you're at, so thank you for joining us today. If there are no further testimonies or comments, Bill 182-37 is duly heard. The committee can still continue to receive written testimony. We have until 4 p.m. November 10th. Please address all testimony to Senator Sabina Flores Perez, Chairperson of the Committee on Environment, Revenue and Taxation, Labor, Procurement, Statistics, Research, and Planning. It can be dropped off at the mailboxes here at the Guam Congress Building or emailed to office@senatorperez.org. The committee will now adjourn. The time is now 3:29 p.m. Thank you so much. Have a great day and weekend as well.